A doorbell rings in a storm. A gavel drops in a quiet room. Two cases, two thresholds, and two very different outcomes ahead. Twistedcase. Documentary precise. Morally grounded. If careful reporting matters to you, subscribe now. We earn your time by putting human stakes first. Tonight, we follow two real cases unfolding in the United States. Case 1, Florida. A young woman, Tania Wise, was 8.5 months pregnant. She disappeared and was later found in a roadside drainage ditch on Florida's Treasure Coast. Investigators focused on a man named Jose Antonio Soto-Escalera. He and Tania had a relationship. DNA would confirm he was the father of the unborn child. A jury has now convicted him of first-degree murder and recommended the death penalty. The judge will decide the final sentence after a formal hearing. Case 2, New York. In Midtown Manhattan, Brian Thompson, the chief executive of UnitedHealthcare, walked out of a hotel and was shot and killed in public. The suspect, Luigi Mangione, was arrested. State prosecutors initially charged him with murder as an act of terrorism. But a New York judge ruled the terrorism counts were legally insufficient and dismissed them. The state murder charge remains, and in a separate federal case, prosecutors have filed a notice of intent to seek the death penalty. The same country, two rooms. One case pushes toward execution, the other pulls a powerful word, terrorism, off the table. Victim: Tania Wise, 23 years old, heavily pregnant with a son she planned to name Josiah. Discovery: found face down in a roadside drainage ditch. Relationship: she knew Jose Antonio Soto-Escalera. Evidence established that he was the child's father. 2018, incident year. That's when her life ended. Trial result: a jury convicted Soto-Escalera of first-degree murder. Penalty phase: the same jury later recommended death by an 8-4 vote. What's next? A Spencer hearing, Florida's required step where the judge considers mitigation and final arguments before imposing sentence. Let's make it plain. Language explanation. Florida divides a capital trial into two parts. First, guilt or innocence. Second, if guilty, a separate penalty phase. Jurors hear aggravating and mitigating factors. They vote on a recommendation. The judge then holds a Spencer hearing, a formal session to listen to any final mitigation and to weigh everything before the court. Only after that hearing does the judge impose the final sentence. Why prosecutors say this is a death case? Prosecutors told jurors that Soto-Escalera killed Tania Wise to hide an affair and the pending birth. The state argued this was premeditated, cruel, and targeted at a vulnerable victim and an almost born child. In their view, this crime tears at the basic trust inside a home and destroys two futures at once. Most of us can understand a simple truth. A mother had plans, a family had hope, and a community expected a baby. A death sentence will not bring them back, but some jurors believe it can speak the weight of what was taken. Victim: Brian Thompson, CEO of UnitedHealthcare. Location: a public sidewalk outside a hotel. Morning routine. Arrest: Luigi Mangione, 27, taken into custody after the shooting. State charges included murder as an act of terrorism, later dismissed by a judge. The ordinary second-degree murder charge remains. And a federal overlay: separate federal prosecutors have filed a notice of intent to seek the death penalty. What terrorism means in New York law. New York's post-9/11 statute targets violence done with the intent to intimidate or coerce a civilian population or to influence government policy by intimidation or coercion. The judge reviewed the evidence and the defendant's writings. He concluded that while the killing was intentional and planned, the proof did not show the required intent to terrorize a broader population. The act was targeted at one person in public, not designed to spread fear widely. Because of that, the terrorism counts were dismissed as legally insufficient. What still remains? The state's murder charge continues. The federal case, with its separate standards, moves forward, and it carries its own path toward a potential death penalty. In every documentary, we place the official story next to the pressure points. Viewers deserve both. Florida official story. Motive: eliminate exposure of an affair and an imminent birth. Evidence: discovery site, forensic analysis, DNA confirming paternity, timelines built from phone data, and witness statements. Outcome: guilty of first-degree murder, jury recommends death. Florida pressure points. Intent versus panic. Was the crime a long-planned act or a desperate, immediate decision? The law calls it premeditated, but human behavior can still be messy. Timeline gaps. Not every minute is publicly detailed. Transcripts fill in the edges, but documentaries respect what is verified. Consequence: an 8-4 death recommendation shows consensus but not unanimity. Those 4 votes for life remind us that reasonable people can weigh the same facts and disagree on punishment. New York official story. Motive claimed by prosecutors: a political message tied to healthcare, an act meant to send a warning to a workforce and, by extension, the public. Legal approach: charge terrorism to reflect that broader intimidation. New York pressure points. Statutory intent: the judge did not find evidence of a plan to intimidate a civilian population. He saw a targeted killing with political rhetoric around it, not a campaign to spread fears citywide. So we ask, are these outcomes inconsistent, or are they carefully tailored? One case tightens punishment, the other tightens language. That tension carries us into the breakpoints. Deliver these beats cleanly, one sentence at a time. Florida. The jury files in. They recommend death. 8 for death, 4 for life. The judge schedules a Spencer hearing before final sentencing. New York. The judge issues a ruling. The terrorism charges are dismissed as legally insufficient. The state murder charge continues. The federal death penalty path remains. We stack developments, each ending on a small cliff. We do not repeat, we add. Beat 1. Florida. How an 8-4 vote works. Florida law allows a death recommendation without unanimity. An 8-4 recommendation is legally valid. The judge is not bound by it, but it carries weight. Defense attorneys will present mitigation at the Spencer hearing: childhood history, mental health, remorse, anything that can persuade a judge to choose life without parole instead of death. The state will argue aggravation, vulnerability of the victim, premeditation, and the killing of a nearly full-term child. Which voice will the judge hear most clearly? Mitigation or aggravation? Beat 2. Florida. The community's response. In the gallery, family members hold photos. A mother, Elizabeth Batola, speaks about Tania and about the baby who never took a breath. The courtroom offers a public language for private grief. Some residents say the death recommendation feels like justice. Others prefer life without parole, believing that a living sentence is a clearer statement of restraint. Will the court's final sentence calm the community or divide it further? Beat 3. New York. Why the terrorism label fell. The judge's opinion explains the decision. New York's terrorism statute aims at acts designed to frighten a population, not just to kill a specific person for a political reason. The defendant's writings criticized the healthcare system, but they distinguished his conduct from indiscriminate attacks. The judge read those writings, looked at the single victim targeting, and concluded the proof did not reach the statutory threshold. The law, he wrote in essence, must stay tethered to its purpose. If not terrorism, then what is the right label for a public, political killing? Beat 4. New York. The federal case changes the stakes. Separate from the state court, federal prosecutors filed a notice of intent to seek the death penalty. Under our system, state and federal governments are different sovereigns. They can both prosecute the same conduct under different laws. The federal case will follow its own schedule and standards. The absence of the word terrorism in state court does not prevent the maximum federal penalty. Does the federal death notice align punishment with public harm or risk overreach? Beat 5. Street level and optics. Outside the Manhattan courthouse, a few supporters show up with signs about healthcare. Cameras point their way because visuals drive news cycles. Inside, the legal work is drier but decisive. Printed opinions, statutory citations, and a clerk reading the case name. The public square is loud, the courtroom is careful. Which space will shape public opinion? The sidewalk or the statute book? Beat 6. The double life reveal. Every domestic homicide carries a painful pattern. Photographs of normal days, then a file of evidence that tells a second story. Friends remember cookouts and holiday lights. Detectives remember timelines and autopsy reports. The difference between how a person appears and what a person decides in a private hour is the gap we never fully close. Can any sentence close that gap, or only mark it? By the time Florida's rain lifts off the roads and Midtown's glass cools in late afternoon, two judges stand in different places with the same burden. One weighing whether to adopt an 8-4 jury recommendation for death after a young mother and her unborn son were killed to hide a secret. The other trimming an indictment back to a word the statute can support after a targeted political shooting on a public sidewalk. Both facing the simple but heavy task of naming what happened and choosing what should follow. One may sign a death warrant, the other refuses to sign the word terror. Florida. What this likely means next. After the Spencer hearing, the judge will impose either death or life without the possibility of parole. Whatever the choice, appeals will follow. The family will still go home to a quiet they did not choose. The community will still remember a due date that never came. A sentence can mark the harm, it cannot reverse it. New York. What this ruling clarifies. The dismissal of state terrorism counts does not lessen the killing. It preserves a clear meaning for terrorism in New York law. The state case continues as murder. The federal death penalty path remains in motion. Two systems will now test proportionality in different ways. The wider lesson. Words and punishments are neighbors. If we let words swell too large, they stop guiding us. If we make punishments our only language, we risk missing why crimes happen and how communities heal. These two cases remind us to do both. Speak precisely and weigh consequences carefully. Tania Wise and her unborn son Josiah should be at the front of this story. Tania had a home, a family, and a set of ordinary hopes. Baby clothes, clinic visits, a name chosen in love. The evidence says someone decided to silence that future. The jury answered with a death recommendation. The judge will decide whether the state should take a life in return. Brian Thompson left the hotel for a normal morning. A shooter ended that routine in seconds. The state tried to frame the killing as terror. A judge said the law did not reach that far. The federal government may still push for the ultimate penalty, but on different grounds. The grief in both rooms is real, and undeserved. A documentary earns trust by keeping that grief in view. What is a Spencer hearing? It is a Florida proceeding where, after a jury recommends a penalty in a capital case, the judge holds a hearing to consider mitigation and any final arguments before imposing sentence. It is a safeguard to ensure the judge hears everything on the record before making the final decision. Why did the judge dismiss terrorism in New York? Because the evidence did not show the specific intent the statute requires, to intimidate or coerce a civilian population. A targeted killing with political language around it is still murder, but it is not necessarily terrorism under New York law unless that broader intent is proven. How can both state and federal cases exist? In the United States, state and federal systems are separate. Each can bring charges based on the same conduct under different laws. That is why the New York state case can move forward as murder, while the federal case can pursue a death sentence. Does a death recommendation mean death is certain? No. It is a strong signal, but the judge imposes the final sentence. Appeals can last years. The process is slow by design. We avoid glamorizing violence or turning defendants into anti-heroes. We center victims and survivors. We use words the way courts do, carefully. The term terrorism belongs where statutes put it, not where headlines want it. The term death penalty should be used with the weight it carries. We tell what is verified and label what is uncertain. That is how trust is built. 2018, Florida. Tania Wise killed late in pregnancy. Trial, Florida. Jury convicts Jose Antonio Soto-Escalera of first-degree murder. Penalty, Florida. Jury recommends death by 8-4. Spencer hearing set before final sentencing. 2025, New York. Brian Thompson killed. Luigi Mangione charged. State ruling, New York. Judge dismisses terrorism counts. Murder charge remains. Federal notice, New York. Prosecutors announce intent to seek the death penalty. We do not end with certainty. We end with the choice citizens must debate. Florida. Should the state answer an intimate, premeditated killing of a pregnant partner with the death penalty? Or is life without parole a stronger statement of value and restraint? Which sentence protects the living more? And why? New York. Should a targeted, politically motivated killing aimed at making a public point be labeled terrorism? Or must terror remain a term for acts designed to frighten a population at large? Where would you draw that line, and what risks follow? Share your reasons, not just your votes. Keep it respectful. We will feature thoughtful comments in a follow-up. This is Twisted Case. If this work helped you understand a hard story, subscribe. It keeps long-form, careful reporting alive. If you want more episodes that treat hard cases with care and clarity, hit subscribe and share. Your support lets us keep the lights low and the questions honest.